Well, a very good morning again, everyone. My name is David Bates. I am the Managing Director here at Workforce Guardian, and I'll be your presenter for today's webinar. It's just gone 10 a.m. Australian Eastern Daylight Saving Time, so I am going to start the webinar right on time. Many thanks for all of you who've joined us for this morning's webinar, and a special thanks to all of you who attempted to join us for this webinar around 48 hours ago. Unfortunately, due to circumstances well beyond our control here at Workforce Guardian and ADP, that webinar was not able to proceed due to a technical fault. So for all of you who've managed to take time out of your day today to join me, my very, very sincere thanks. I do appreciate as well that for those of you who are in Western states, the time difference means that some of you have had to get up quite early for the webinar. That's also very much appreciated. And just a heads up as well that we are recording the webinars so that anyone who can't join us for whatever reason can always view the webinars later on at a time that's convenient to them. We will post the webinars onto the various YouTube channels that are available to you from ADP and from Workforce Guardian. All right, I mentioned a few moments ago that it would be a great idea maybe for you to have a pen and paper handy. During the course of this 30-minute webinar, we will be going through quite a bit of information, so you may want to take notes down as you go through. So a pen and paper will be very handy for that. A nice cup of tea or a cup of coffee is probably in order as well, and without further ado, we are going to get stuck in. So for all of you who've maybe not heard of Workforce Guardian or not really au fait with how we fit in with the range of services that are available to you from ADP, I just want to mention that Workforce Guardian has been a partner with ADP for quite some time now, almost I think 5 years. One of the key benefits that we provide to ADP clients is the ADP Workplace Advice Line. And at the end of the webinar, I will mention that you obviously have access to that phone advice service. It's an incredibly valuable addition, if you like, to your range of services that are available to you from ADP. Another great reason to be an ADP client. And that Workplace Advice Line is proudly brought to you by the team here at Workforce Guardian. So when you phone through, you are actually speaking to someone from the team here at Workforce Guardian, and their job is to make it easy for you to understand and comply with all of your obligations under Australia's Fair Work laws. Now, speaking of the Fair Work laws, we know that they are very complex. We know that they're very tricky, and that's why we've decided to run this webinar series in conjunction with ADP across 2015. Now, I will, at the end of the webinar, give you a heads up about all of the future webinars in this series, but in a nutshell, there are 10 webinars that we'll be running through the course of the year, one each month from now going forward until November, and the idea is that by the end of that webinar series, you will all have a really great idea about how the Fair Work Act and how the Fair Work laws in general apply to you and your workplace. So it's a fantastic opportunity, really, to become quite familiar with how the Fair Work laws operate in practice, and we're going to do that in a nice, interactive, informal way so that it's not a horrendously dry legal lecture. The idea is that it should all be very, very practical, very, very easy for you to apply in your own workplaces. All right, so what do we do at Workforce Guardian with ADP that makes it easy for you to be able to comply with all of these quite complex laws? Well, the idea of our service, which was launched back in 2007, is to make it easy, cost-effective, and simple for employers to hire, manage, and dismiss employees in full compliance with the legislation, and that means that you've got the confidence that you need to be able to do those things. In addition, the service features everything that you need to generate contracts of employment, to receive unlimited online advice and support, so that's written advice, in addition to the phone-based advice that you can access via the ADP Workplace Advice Line. You can safely store all of your employment-related records in your Workforce Guardian from ADP system, and as I mentioned, it really does ensure that you're operating in full compliance with the legislation, and that gives you something which is fairly priceless, and that's complete peace of mind. We know that many, many employers end their working days thinking about all of the things that maybe they should have done, all the risks that their businesses face, and one of the biggest of those risks are your people, are your employees, and non-compliance with the legislation. So the beauty of Workforce Guardian from ADP is that it provides that solution that you might be looking for, maybe even the solution you didn't know you need to all of these difficult HR situations. So, having said all of that, what are we going to cover in the very first of these 10 webinars about the Fair Work laws? Well, as the title suggests, the aim of the game today is to provide you with a nice, straightforward, plain English introduction to what these Fair Work laws are all about. So we're going to start off with what I call Fair Work 101, the general introduction to what the Fair Work laws are all about. In other words, how the different parts of these Fair Work laws fit together so that you can understand the relationship between things like the National Employment Standards, modern awards, and your record-keeping obligations. So I'll explain that at the outset. I'll then go in and talk about the National Employment Standards in a little bit more detail, before then looking at what we call the modern awards, these 122 modern awards. We'll then talk about termination and redundancy and the obligations that apply to your workplace under the Fair Work laws in relation to letting people go. And we'll finish off with a quick overview of your record-keeping obligations. Now, I do want to emphasise that all of those different topics, the NES, modern awards, termination and record-keeping obligations, those topics are in fact subject to their own webinars in this webinar series. So today, for example, while I'll touch on the National Employment Standards, and we will mention what each of them actually is, if you would like a lot more detail about the National Employment Standards, then I would really encourage you to register for the next 2 webinars in the series, which will look at the NES in a lot more detail. So the first of those webinars will talk about the first 5 NES, and in the second webinar in that series we'll look at the second group of 5 National Employment Standards. So as you can see, the webinar series builds on each webinar before it. So if you can, join us for all 10, and by the end of it you should have a really, really good understanding of what your obligations are. Okay, so they're the key topics that we're going to go through today. Let's kick off with Fair Work 101. So the first thing to note is that we have this piece of legislation called the Fair Work Act 2009. Now, the Fair Work Act 2009 took part effect on the 1st of July, that's 2009, and the rest of the legislation, specifically the parts that deal with the National Employment Standards, modern award compliance, etc., didn't take effect until 6 months later on the 1st of January 2010. Now that 6-month gap is actually very important because what the Commonwealth Government, and indeed what the Fair Work Commission, the tribunal, say is that during that 6-month period, way back in 2009, you had the opportunity to become fully aware of all of your Fair Work related obligations. Now, that sounds great in theory, but we know in practice that many, many of you simply could not possibly have gotten across all of your new obligations during that 1 6-month period. So we know it's a really, really complex detail, and you know it's not something that you can really get across in just a 6-month period of time. Indeed, the Commonwealth Government also launched what was called the Fair Work Information Education Campaign. And that education campaign lasted 1 week, and it ran in the first week of 2010. So I think most of you were probably on leave during that time or enjoying some roast ham, and therefore couldn't roast turkey, I should say, and therefore you probably didn't have the time to get across all of your obligations. But I can say that when we get to the Fair Work Commission, when cases are actually brought by aggrieved ex-employees, that is certainly something that the Commission says. They will say that you had 6 months to get across it, and of course it's been 5 years since then now. So plenty of time to get across the key concepts. Most people haven't been able to do that, and that's why we're here today. What the Fair Work Act did, importantly, was it removed many of the workplace flexibilities that employers had gotten used to. And I'll give you a clear example. Let's say you had an employee that would like to cash out their annual leave rather than actually take it. Well, under the old legislation, under work choices, it was possible to reach statutory agreements with employees about certain workplace entitlements. Under the Fair Work Act, it's now unlawful for you to cash out all of an employee's annual leave down to a zero balance while they remain employed by you. And doing that can attract a maximum penalty of $51,000. So there are many flexibilities, if you like, those abilities to reach individual agreements. Many of those flexibilities were removed by the Fair Work laws, and as I've just provided you an example of, there are significant penalties that can be imposed for breaches. It's also worth noting that in addition to the Fair Work Act of 2009, we also have, of course, many other pieces of legislation that apply to your employees. Examples include state-based long service leave entitlements, state-based workplace health and safety laws, and even state-based discrimination laws. So while it's true that the Fair Work Act governs most employment-related entitlements, there are still other state and indeed even some Commonwealth laws that also apply. So it's not an easy thing to get your head around. There's a lot of different pieces of legislation you need to refer to. We get that it's a very, very complex area. Okay, so having established that, let's talk now about the first part of this Fair Work component, if you like, and that's what's called the National Employment Standards. Now, there are 10 National Employment Standards, which we'll look at in a bit more detail in a moment, but the key thing here to note is that the National Employment Standards sit at the bottom. If you like, think of them as the foundation upon which all of the Fair Work system is based. The 10 National Employment Standards then form this foundation upon which everything else is built. And the first thing that's built on top of those National Employment Standards are modern awards. So while National Employment Standards contain 10 minimum safety net entitlements that you must provide to all of your employees, modern awards impose additional terms and conditions of employment that need to be provided on top of the National Employment Standards. So you can't run a business without knowing about both the National Employment Standards and any modern awards that apply. Very important that you have your head around both. In addition, the Fair Work Act also imposes obligations in relation to termination and record keeping, and we're going to talk about both of those again today as well. Termination, the notice obligations that you have, the process you need to follow, that's all tied up with the types of claims that people can bring against your business if they are dismissed incorrectly. Record keeping is all about the pay slips and the time and wages records that you maintain in your workplace. So whenever you think about the Fair Work laws, whenever you start hearing people talk about the Fair Work Act, I want you to think about this particular image that you've got on your screens right now, and I just want you to keep in mind how they fit together. So NES at the bottom, modern awards building on top, and then your separate obligations in relation to dismissals or terminations and your record keeping requirements. That's a really handy way to understand, if you like, in a snapshot, how the laws fit together. Now, you might have heard something called enterprise agreements. Enterprise agreements are collective employment agreements that are negotiated between employers and their employees. Once an enterprise agreement has been negotiated in a workplace, and once it's been approved by the relevant authority, which is called a Fair Work Commission, once that happens, the enterprise agreement effectively replaces the modern award. So you can see here how once the agreement is in place, the modern award effectively no longer applies, and the enterprise agreement will replace it. The enterprise agreement also builds on top of the National Employment Standards, and most enterprise agreements will simply incorporate those NES entitlements into the agreement itself. Okay, so now that you've got a good understanding about how the Fair Work laws fit together, the different components, I just want to make a couple of quick comments about contracts of employment. Now, whether you provide employees with written contracts or not is really irrelevant from a legal perspective, because under common law, under Australian legislation, and by the law that's developed over time in the courts, the fact is that every employee has a contract, whether it's been written down or not, and that is what's called a common law contract. So if you approached me and asked to work in Workforce Guardian, and I offered you a position and you started work, as soon as I've effectively agreed to that arrangement and you start and I pay you, we have a binding legal contract. It's called a common law employment contract. There's no legal obligation in Australia for me to put that contract into writing, but it's a great idea if I do. And the reason for that is that the Fair Work Act and modern awards, which are what are known as statutory instruments, that is, they are obligations that are imposed by a law created by Parliament. All of the obligations that arise under those statutory agreements or statutory instruments have to be read into that contract that we've created. So if I don't put the contract in writing, there's likely to be quite a bit of uncertainty or disagreement between me and you about your terms of employment. So the best, most sensible thing to do is put everything into writing so it's clear where your terms and conditions come from and actually what they are. So remember, the Fair Work Act and modern awards will override any contracts that you might have given to your employees to the extent of any inconsistency, unless the contract provides something more generous. So you could issue a contract providing someone with 8 weeks of annual leave per year instead of the mandatory 4 weeks for a full-time employee, but you can't issue a binding contract that only provides someone with 3 weeks of annual leave, and that's because the Fair Work Act will override it. So just keep in mind, in a nutshell, everyone does have a contract, but contracts are subject to statute, and the key statutory instruments to keep in mind are the Fair Work Act and modern awards. Okay, so let's move on now and look at the National Employment Standards in a little bit more detail. As I mentioned, there are 10 of these National Employment Standards, and they are effectively the minimum terms and conditions of employment that have to be provided to almost every Australian employee. Now, not everyone is covered by the Fair Work Act, although there are only a few exceptions. In Western Australia, people who work in private sector businesses that aren't incorporated are still covered by WA state legislation. And indeed, in the rest of the country, people who work in state government organisations, for the most part, are still captured by state law. But everywhere outside of WA, if you work in a private sector business, it's almost certain that you're covered by the Fair Work Act. Those employees need to be provided with the 10 National Employment Standards. Now, you remember my earlier example about an employee who asks if they can cash out all of their annual leave. Well, unfortunately, you can't do that, and that's because the Fair Work Act and the National Employment Standards in particular does not allow that to occur. And that's a good example of how you cannot bargain away or reduce by mutual agreement any of the National Employment Standards. They must be provided, they cannot be altered, and there are penalties that will be imposed for breaches of the National Employment Standards. The maximum penalty for a breach is $51,000. So that's for the business. There can also be personal fines imposed or personal penalties imposed by the Fair Work Commission or by the Federal Court, so it is worthwhile keeping in mind that the NES are definitely non-negotiable. Okay, so what exactly are these 10 National Employment Standards that I'm referring to? Well, they're coming up on your screen now, and I will just mention them one by one so that you've got an understanding of what they are. As I mentioned previously, if you'd like much more information about these NES and how they work in practice, join us for the next 2 webinars in this special series from ADP, where you'll find out all about those NES in a lot of detail. So the first NES is maximum hours of ordinary work, which is set at 38 hours per week. So if you have contracts that refer to a ordinary 40-hour-a-week working contract, I do recommend that you change them. The second NES is parental leave and related entitlements, and here we're talking about unpaid parental leave. A separate entitlement to paid parental leave is created by a separate piece of legislation called the Paid Parental Leave Act of 2010. Next, we've got personal or carers leave, which is the new term for sick leave, as well as compassionate leave. Then there's long service leave. Also, as I mentioned previously, at the moment, long service leave is still governed by state-based legislation in the most part, but eventually the Commonwealth Government intends to replace state-based long service leave laws with one national long service leave entitlement. Then we've got notice of termination and redundancy pay, which again we're going to talk about in a little bit more detail in a moment, and which is also the subject of its own webinar in this series. Number 6 is requests for flexible working arrangements, which can be made by certain eligible employees and which you must respond to in writing within 21 days. Number 7 is the accrual of annual leave, which is 4 weeks for full-time employees, 4 weeks per year. Then we have community service leave, which includes jury service and emergency management activities. Public holidays is number 9, and number 10 is the Fair Work Information Statement. Just a note on the Fair Work Information Statement, that's a document that contains a summary of the terms and conditions of employment that need to be provided to employees. That's a document that you are legally required to give to any new employee, including a casual, that you've employed since the 1st of January 2010. It's an offence under the Fair Work Act to not provide that document to a new employee. So if you haven't been doing that, we obviously strongly encourage you to begin doing it from today. Okay, so that's the National Employment Standards. What about these modern awards that build on top of the NES? Well, modern awards apply to most Australian employees. There are over 100 of them, and they impose additional terms and conditions, which, as I mentioned, sit on top of the National Employment Standard entitlements. Now, typical obligations which are imposed by modern awards include things like having to pay employees certain allowances, paying leave loading when an employee takes annual leave, penalty rates that will apply when employees work particular hours on certain days of the week. So, for example, penalty rates usually apply for work performed on weekends or late at night. And there are many other obligations which are imposed by modern awards which are not found elsewhere in the Fair Work Act or in the National Employment Standards. That really drives home the importance of finding out which modern awards apply to your employees, because if you don't know, it's virtually impossible for you to provide the necessary terms and conditions to those employees. It won't surprise you to learn that there are significant penalties for non-compliance with the modern awards, and again, we're talking about penalties in the range of a maximum of $51,000 per breach. So it's definitely something you want to get right. At the end of the day, though, we know that many, many Australian businesses are still not compliant with their modern award obligations, and that's despite these modern awards now having been around for more than 5 years. Now, what you're seeing on your screen there are the logos for just 4 companies that have found themselves on the wrong side of the law since the commencement of modern awards. All 4 of those businesses have been somehow fined or penalised for breaches of their modern award-related obligations. In the case of Super Amart, the furniture retailer, the overall penalty and back payment was in excess of $1.3 million, so a significant amount. And that all arose as a result of non-compliance with modern award pay requirements. So clearly, even some of the country's biggest businesses, which probably have quite significant HR departments, even those businesses aren't necessarily always able to comply with the legislation. So we do appreciate how difficult it is, particularly for small and medium-sized businesses, to comply with their modern award obligations. A couple of key points to note about modern awards. The first is that awards can be either industry-based or occupation-based. So for example, the award that generally covers retail businesses is called the General Retail Industry Award of 2010. But then in addition to those industry type awards, we have occupation-based awards. So for example, the Clark's Private Sector Award of 2010, which covers people who perform admin and clerical duties in businesses, but which there is no classification for within the industry award. Let me just explain that again in a little bit more plain English. So, we always start off by looking for an industry award first. If an industry award applies to your business and you want to find out if it covers all of your employees, you need to look for a classification in the award that would cover the work being done by someone. Let's say you've got a clerical employee in your business, but your industry award doesn't contain any classifications that would cover a clerical employee. Well, in that case, that employee will be covered by the Clark's Private Sector Award, because the occupation-based award will apply if the industry award does not contain an equivalent classification. So that's an idea, if you like, of the various steps you need to go through to determine modern award coverage. Now, it's also crucial to note that awards apply as a matter of law, not employer choice or indeed employer preference. So that means that even if you would prefer an award not to apply, there's very little you can do about it. If the award coverage clause extends to your industry or the employee's occupation, chances are they're covered. And there are currently 122 of these modern awards, so finding the right award can be a little bit tricky. But despite the difficulty of locating the correct award, it is something that is absolutely essential. Because again, if you don't know which award applies, it's impossible for you to make sure that you're compliant with all of your award-based obligations. So that's modern awards in a nutshell. So far we've covered the 10 minimum employment conditions, the NES. We've then talked about how the modern awards sit on top of the NES, and now we're going to look at termination and redundancy under the Fair Work legislation. Well, I'm sure it doesn't surprise you to learn that someone's employment can end in a number of different ways. The employee could resign voluntarily. They could be dismissed with notice. They could be dismissed without notice, which can only occur in situations of serious misconduct. They could be made redundant, or they could be really terminated, if you like, via a deed of release. Although a deed of release isn't technically a termination, it's kind of like a no-fault divorce. It's a mutual agreement to end the employment relationship. So they're the different ways, generally, that an employment relationship will end in a business. Of course, the one that we would prefer to happen, the preferential outcome, if you like, is the preferred outcome is a resignation. A voluntary resignation will ensure that there can be no claims brought against the business in relation to unfair dismissal. All of the other types of claims can result sometimes in a post-employment claim being made by the employee. The exception to that is if the employee is let go via a deed of release. Now, if someone is dismissed, they can bring a type of claim, number of different claims in fact, to the relevant court or to the Fair Work Commission, which is the Employment Relations Tribunal. The most common types of claims that people bring after being dismissed are for unfair dismissal, unlawful termination, adverse action, or discrimination. Now, of these different types of claims, unfair dismissal are by far the most common. There are over 20,000 unfair dismissal cases each year in Australia, and around 85% of them settle at the first stage of the unfair dismissal hearing process, which I'll talk about in a moment. But effectively, you do need to know about all 4 possible claims that an employee can make, but the one you probably want to be most familiar with are unfair dismissal claims. Now, a dismissal is considered unfair if it occurs in circumstances which are, quote, harsh, unjust, or unreasonable. Generally, a dismissal will be harsh, unjust, or unreasonable if there has been no proper process followed in the lead-up to the dismissal. So, if someone has been with you for a couple of years, you decide that they're really not performing very well and you just decide to let them go without going through any form of performance review or disciplinary process, chances are that would be considered an unfair dismissal. If a dismissal is considered to be unfair by the employee, they can lodge an unfair dismissal claim directly with the Fair Work Commission. The first stage of that process will be for the Fair Work Commission to list the matter for conciliation, and that's an informal telephone-based discussion with a conciliator and both parties to see if they can reach some form of agreement. Now, as I mentioned a moment ago, around 85% of cases end at the conciliation stage, usually because the employer agrees to make some form of financial payment to the employee. It's colloquially known as go-away money. If you don't reach settlement at conciliation, the matter is then listed for formal arbitration before a Fair Work Commissioner. That's where people have to take the stand, have to be sworn in, evidence is presented, and the Commission makes a binding decision as to whether or not the dismissal was unfair or not. If the Commission at arbitration decides that the dismissal was unfair, they can order that the employee be reinstated back to their old position and back paid for all of their lost pay, or they can impose penalties. So, for example, they might award the employee compensation and they might then ask the employer to pay some form of penalty for the unfair nature of the dismissal. So there are different things that can happen, and that's why most employers prefer to have the claim dealt with, if you like, at the conciliation stage. Now, another common way that employees are let go is as a result of what's called a redundancy. But under the Fair Work laws, a redundancy must be genuine. For a redundancy to be genuine, the work must no longer be required, there must have been meaningful consultation with the employee, consideration has to have been given to any reasonable redeployment opportunity, and if the business is not a small business, that is, if the business has 15 or more employees, then a redundancy payment will usually need to be made in addition to the provision of notice. So if an employment relationship is ended for redundancy purposes, but it's not a genuine redundancy, it will be treated in the same way by the Fair Work Commission as an unfair dismissal. So it is important that redundancies are genuine. Once again, we've got a very detailed webinar in this series that will focus on redundancies and dismissals. So if you'd like more information about those, please do make sure that you register for those webinars. Okay, let's finish off by looking at your record-keeping obligations. There are two key employment records that you need to maintain. The first is what's called your time and wages records for each of your employees, and the second are your pay slips. Both of these records must contain certain mandatory information. For example, there is a quite comprehensive list in the Fair Work Regulations about what needs to appear in your time and wages records, things like your ABN, for example. Similarly, there are things that must appear on pay slips. Let's say you have a casual employee in your workplace. The casual employee's pay slip must show their base rate of pay, and it must also show as a separate amount the casual loading that they've received. That's the compulsory 25% casual loading imposed by most modern awards. Most of the information that has to be contained on these records is relatively straightforward, but the lists of information are quite long. So you do want to make sure that you are meeting all of your obligations. And if you'd like to see more about what has to appear on your time and wages records and on your pay slips, then I do encourage you to have a look at the lists that are available on your Workforce Guardian from ADP subscription service. If you don't comply with your record-keeping obligations, a Fair Work Inspector has the power to issue on-the-spot fines of $510 per breach. That's quite a bit of money, especially if they discover a lot of breaches in one hit. So again, very important that you are mindful of your record-keeping obligations. Okay, so let's recap how all of these different things that we've just discussed fit together. At the beginning of the webinar, you'll remember this slide. So at the bottom, we've looked at the 10 national employment standards. Then you've got those modern awards sitting on top with additional terms and conditions of employment, such as penalty rates, overtime, and allowances. And then we have your separate obligations arising under the Fair Work Act relating to termination and record keeping. So again, a really handy way to visualize how these different pieces fit together. Okay, so during the course of the webinar, I've mentioned that this is part of a whole series of webinars. Well, here are the other ones on your screen now. You'll see the next two focus on the National Employment Standard. We'll then spend a dedicated webinar looking at modern awards. We'll then go on to look at employment contracts, then how you can find the correct rate of pay for your employees. In August, we're going to talk about how to make sure that you dismiss your employees without facing expensive unfair dismissal claims. The September focus will be on workplace health and safety. In October, we'll look at workplace bullying and stress, and we'll end off the year in November with a webinar focused on the 5 most common HR mistakes and, of course, how you can avoid them. So that's the full 2015 Workforce Guardian from ADP webinar series, and I do hope that you're able to join me for all of those webinars. Now, if you'd like to find out more about the Workforce Guardian subscription service from ADP, please visit adppayroll.com.au/contact, or you can phone the friendly ADP team on 1-800-000-729. As an existing ADP client, it's also worth remembering that you have access right now to the ADP Workplace Advice Line, and the number for that service is now on your screen. That service is open from 9 a.m. to 5 p.m. Sydney time, Monday to Friday, on all days other than New South Wales and Commonwealth public holiday. So really, really valuable benefit of being an ADP client. Well, ladies and gentlemen, all that remains is for me to say thank you very much for attending today's webinar. Again, my sincere apologies and deep appreciation for all of you who tried to join us 2 days ago and weren't able to. I'm really thrilled that you were able to join us again today. For those of you who are listening to this webinar in the future via the recording, I do hope that it's been worthwhile as well, and I hope that I'll have the company of all of you at one of our further 9 webinars in this series across 2015. On behalf of the entire team at Workforce Guardian from ADP, thanks again and have a great day.